Welcome, I'm Jon Caldara, president of the Independence Institute and your Devil's Advocate, a special show today. As we tape this, it was mere hours ago that the Supreme Court decision came down on Obamacare, the Affordable Health Care Act. To help me dissect that, someone who was actually involved in that fight from the University of Denver and the Independence Institute, Dave Kopel.
Yes, and I submitted 2 briefs on behalf of the Independence Institute to the Supreme Court in the case. So we all have a dog in this fight.
I tell you what, before we get into what you and Rob Nadelson put together for this amicus brief, let's lay down the background here. This law came into effect almost 2 years ago, and the crux of the constitutional question on Obamacare was what?
Well, there are lots of Obamacare cases that are still going to go on. There are many other parts of the law that are constitutionally problematic. The parts that the Supreme Court ruled on were 2. One is a requirement that in the Medicaid program, that's a medical welfare program for some people, which is funded by a combination of state money and federal money. There is a requirement that either states drastically expand Medicare coverage. So for the first time ever, states would have to cover adults, able-bodied adults with no children who are above the poverty line as part of Medicaid. And if they didn't do that, they would lose all of their Medicaid funding. And Medicaid in Colorado is about 20% of the state budget. So that was a drastic sanction.
Let me kick this back, because I understand sometimes when we lay people think of what the Supreme Court does, we expect it to be a vote as if it were on a bill, up or down. But that's really not the way it works. The Supreme Court or any court really looks at the whole package and says, this part unconstitutional, this part okay when you look at it this way, this part constitutional, but you have to look at it that way. Would that be the right way to?
That's right. And this, Obamacare bill is an enormous thing with many, many different legal issues in it. The Supreme Court looked at 2 very important ones in it. One was the individual mandate, and one was the Medicaid mandate. And the court, by a vote of 7-2, found that the Medicaid mandate was unconstitutional. Congress can't order states to transform their Medicaid programs, drastically expanding them, and say, if you don't do that, you're going to lose all your Medicaid money.
The idea is that states still have a certain 10th Amendment right. They're still sovereign in that they have ability to run their business the way they want to. And so that decision, this was the good part of this decision from my point of view. The Supreme Court said you can't force states to change their Medicaid systems if they don't want to change it.
That's exactly right, at least when the sanction is as drastic as this loss of a huge share of their state budgets. There's a previous case from '87, which was reaffirmed, that says if you don't raise your drinking age from 18 to 21, you will lose 5% of your federal highway funding. And the court today, and we're taping this tomorrow, or vice versa, something like that.
Something like that.
The Supreme Court ruled that something that amounts to less than 0.5% of your state budget, that can be used as a carrot and stick kind of thing. But when it gets to such a massive level as Medicaid, that goes too far. That's more than a reasonable inducement. It's putting a gun to the head of the states, in the words of the Supreme Court. So
in this one area, when it comes to Medicaid, the states won.
Absolutely.
And a slam dunk win. That portion of it was a big win.
And it wasn't a 5-4, it was a 7-2. Justices Kagan and Breyer joined in that part of the opinion. This is a very strong endorsement across the court's ideological divide against Congress going too far in trying to coerce states by threatening to cut off matching grants.
And let's be clear that you and your colleague at the Independence Institute, Rob Nadelson, put together an amicus brief, which is a friend of the court brief, to bring up this issue. And as we haven't seen another brief that dealt with the Medicaid issue other than the one that you and Rob wrote.
Well, not that dealt with it, what we did was sort of a back-to-basics approach of let's talk about the structure of the Constitution, how both the text and everything around it recognize the states as independent and sovereign within their own spheres. Obviously, they're not sovereign in foreign policy or other things, but it's the independence and sovereignty of the states was the core of what we talked about in the original meaning, and how that's been affirmed by the court in decisions all the way up through the recent past. And the court opinion seemed to follow that approach. I'm not sure they needed us to tell them that it existed, but they certainly took the same approach, the 7 justices, as we did, which is this is a very basic structural issue. As the court said, the states are sovereign and independent, and sometimes that means exercising your sovereignty and independence, including choosing not to participate in this massive expansion of a federal welfare program.
But how does that jive with the other big decision that came down yesterday, which was the mandate, the individual mandate? You, by breathing, you will have to purchase a product designed by the government. And they ruled, and let me see if I understand this correctly. The Supreme Court ruled it is unconstitutional to use the Commerce Clause to force you to buy this product just because you breathe. But if you don't buy it, it's perfectly within the Constitution for the feds to tax you for your inactivity.
Yes, that's right. So the Constitution grants Congress the power to regulate commerce among the several states. The court clearly said you can use that to regulate commerce that's going on, but you can't use that power to call commerce into being. If somebody's just sitting at home and not doing anything commercial, you can't make him go out and buy something and call that a regulation of interstate commerce. And
I'm so confused by this, so help me out. So the decision yesterday said if somebody's sitting alone in their couch, not hurting anybody, not talking to anybody, eating their ding-dongs and watching Monday Night Football, and the feds can't come in and say, you will buy something. They
Yes.
can't say that. But the feds can come into their home and say, if you don't buy this something, we're going to tax you.
That's exactly right, because Congress has they have the power to regulate interstate commerce, and they have a separate power to tax. And the court ruled that it's not valid under the commerce power to the individual mandate, but that if you read the individual mandate narrowly, it can be upheld under the tax power. But here's an important distinction that Chief Justice Roberts' opinion makes. If it were valid under the commerce power, then Congress gets the full scope of all the other ways you can enforce things enacted under the commerce power, such as prison, the federal criminal justice system. So Congress, if the mandate had been upheld under the commerce power, then Congress could say, and if you don't buy this, that's a felony, and we can prosecute you and we can put you in federal prison for 5 years.
We can put you in prison for inactivity, for not doing something.
Not under the court's holding.
No, right. If the court said the mandate is constitutional because of the Commerce Clause, you're saying then a person, the Congress could say, if you don't drink 3 gallons of beer a day, we can put you in prison. And you'd have to.
Or if you don't eat broccoli, or if you do whatever, or in a more practical sense for how these mandates could have easily been expanded, to say that if you're one business and you don't buy your products in a particular way, but you instead buy some other kind of products, that you can go to prison for that. So that's out in a very strong decision from the court.
So when it comes to the Commerce Clause, which I think both you and I believe has been perverted beyond degree over the last several decades, this was a good way to rein in the Commerce Clause, saying you can't force individuals to do something and use the Commerce Clause to do it.
Exactly.
All right, then let me go to the next one. How is that different if we say, if you don't do what we want to do, we'll tax you? And we might be able to tax you so much that if you don't pay, you'll end up in debtor's prison, or we'll take away everything you have. What I don't understand.
Well, Chief Justice Roberts would, in his opinion, offers 2 distinctions. First of all, if something is taxable, you always have the choice. You can either do whatever's taxable and pay the tax, or not. So if there's a tax on gasoline, if you don't want to pay the tax, don't buy gasoline. And he would analogize that and say, so if you don't want to be taxed for not having congressionally designed health insurance, well, then go buy the health insurance. But so you always have, you're not compelled into the activity. In other words, you can be a law-abiding person. Either way, you can either, and this is it's maybe not exactly how the statute was actually enacted by Congress, but in the way the Solicitor General defended it in Congress, they very strongly argued for the interpretation that there's always the choice. You either, if you want to buy the insurance, go ahead and buy the insurance, and if you don't, pay the tax, you always have the choice, and if you're a guy who says, I'm always strictly law-abiding, I stop at the walk, don't walk sign, even if there's no traffic for 100 miles around, and I wait till the sign says that I can walk. You want to be that strictly law-abiding guy? According to the Solicitor General and now the Supreme Court, you can be that strictly law-abiding guy by absolutely refusing to ever buy the Obamacare health insurance. You simply pay a tax.
Instead, you pay the penalty for not taking that
Well,
activity.
in their view, it's not a penalty. It's a penalty is something that you do if you did something wrong.
How is it not a penalty? I refuse to take an action in order to not play with you. I now have to give you money. I'm sorry, but Tony Soprano works this way. You want us to leave you alone? You have to give us some money.
Yes, but Chief Justice Roberts also goes on to say that while Congress has a lot of discretion in how it sets taxing levels, the court will also recognize and does enforce when something goes so far beyond the bounds of anything that can reasonably be called a tax that it's really just a penalty in the guise of a tax. But he says that the amount of taxes that you have to pay for not buying Obamacare insurance are so low that they don't even come close to that issue.
It sounds to me, though, like a head tax, that since you exist, you either will pay this tax or pay for this insurance. I've heard that a head tax is unconstitutional. The feds can't just say, because you live in the United States, you owe us $5,000 a year.
Well, what you call a head tax is a good example of what's called a direct tax. And Congress does have the power to enact direct taxes, but they have to be apportioned by state population. So, for example, if Congress enacted a law that says everybody has to pay the government, the U.S. government, $100, that's a direct tax. It's not based on anything you did, it's just because you exist in the United States. And the way I just described it, it would be apportioned by state population because everybody would be paying. If Colorado has 1% of the state population, of the U.S. population, then Coloradans would pay 1% of the total tax. But the Obamacare tax is not apportioned by state population. It has nothing to do with that. You wouldn't expect, there's nothing to make sure that Colorado with 1% of the U.S. population, say, pays 1% of the tax. So it is not a direct tax or a head tax, according to the way Chief Justice Roberts described it. Now, I think you could make a good legal argument that he was wrong on that it in fact is a type of a head tax and unconstitutional because not apportioned.
Let's talk a little bit about how these decisions are made, because it's not the same as in the legislative branch. We all think that government is guys sitting at the podium or the desk and they press the right button or they raise their hand or they say yay or nay and the votes are counted and there it's done. A Supreme Court decision is a bit more collaborative. That is, after they hear the arguments, after they read the briefs, they all get together around a table basically, discuss it, and almost come to a consensus. Is it true that there's some sort of almost bargaining, which is, hey, if your argument is we're doing this, then I'm not going to be with you. But if your argument is that, yeah, I can go along with this.
Well, a few days after the oral argument, they meet in a conference and they go around the table, going from the least senior to the most senior justice, except that the Chief Justice is always the most senior, regardless of how long he's been on the court. And they indicate how they would vote on the different things. Now, in the Obamacare cases, there were actually 4 separate issues they had to vote on. And the Chief Justice votes last. And then on each particular opinion that has to be written, the most senior justice, well, again, the Chief Justice is always the most senior, assigns who will write the opinion. So Chief Justice Roberts voted last on these issues and had the control of who would write the opinion, which he assigned to himself. Now, as opinions are being written, sometimes people can change their minds. So let's say there's 5 justices who want to go one way, and let's say Justice Scalia is writing the opinion for 5 who voted one way. As he's writing the opinion, there'll be circulating drafts within the chambers of the other justices, and let's say Justice Kennedy is going along with Justice Scalia on this, says, I agree with you, Mr. Justice Scalia, on the result, but some of the language you're using here pushes the law too far. If you insist on keeping this language in, I'm not sure I can stick with you on your opinion. And occasionally you'll even have justices who switch sides. Okay. So there is that kind of bargaining about what exactly the opinion will say.
Then gossip with me for a little bit here. Out of all the justices to vote that this is constitutional in any way, Roberts was not really on my radar screen. Everyone seemed to be focusing in on Kennedy, and that a lot of the arguments seemed to be focused on convincing Kennedy, who's often the swing on this, and instead it was Justice Roberts, the Chief Justice. Well, did that surprise you?
Not in the slightest.
Really? Tell me.
Well, first of all, Justice Kennedy, who does, if you say that there's the four on one side and the four on the other, he often is the swing between them. Justice Kennedy is more libertarian than anybody else on the court, which doesn't make him a high-end libertarian, but he has more of that inclination than any of the others. He respects originalism, but he's not a real hardcore or originalist like Justice Thomas, or a faint-hearted originalist like Justice Scalia, as Scalia describes himself. He's really concerned with liberty in a broad sense, and informed by a Catholic sensibility of human rights, which is why he'll sometimes end up with the left wing of the court on one issue and on the right wing on another issue. And it was pretty clear from the oral argument, and even from what we've seen of him in over more than a quarter century on the court, that he recognized this as a serious intrusion into people's personal life, their personal choices, and their entire relation to the government. Chief Justice Roberts has been a color within the lines person his entire life. And of course,
how do you mean that?
He does everything right. If you want to think of the kid who had the perfect attendance record in third grade, who was never reprimanded by the teacher for getting out of line during recess, and you go all the way up of who had not only the straight A's, but a lot of A pluses, who wrote an essay that didn't push the ideological boundaries of whatever class he was in.
He fit in.
He fit in perfectly all the way up through Harvard Law School and
this is a guy
beyond.
who does not make waves. Is this a? I've heard people talk about the Georgetown cocktail party circuit. That we always wonder why Republican picks for the Supreme Court over time tend to drift towards the left. You know, whether it's Sandra Day O'Connor and Souter being a great example of that. But we don't see too many Democratic picks for the Supreme Court turn to the right. One explanation is that they're still surrounded in the Beltway. They're still part of a social scene. They don't want to be the outlier. They want to be respected, and they want to make sure that when the wife goes to the cocktail party, people aren't going, what did your husband do? Is there social pressure there? Because this still boggles my mind.
On O'Connor, I don't think she drifted left, but I think she got a lot more confident about her intuitions being a legitimate basis for how the law should develop, and got less concerned about precedent and those other things as time went on. I think there is a social scene in Washington, but I don't see Chief Justice Roberts as being influenced by that. The point, he's not like, say, Justice Souter or even Justice Stevens, who came to Washington from someplace else, and you would say, well, once he's there and he's living in a new environment, that might affect him. He's been part of Washington for a very long time. He's been part of the Northeastern establishment. Now, the respectable Republican wing of the Northeastern establishment, but still he has been a creature of that Beltway establishment from the day that he became eligible to be part of it. So he's not, I think, concerned about how people are going to flatter him at Georgetown cocktail parties.
Then how did he get to this decision? Why did you suspect he might vote that way? And for me, I was completely surprised. I thought he was the right vote. I thought this would be a 5-4 on the mandate, and some other things would go the other way.
He is a Washington establishmentarian, and that will color one's views about the legitimate scope of what Washington can do. If you really want to get inside his head, which we're not going to, historians in 70 years, when they're looking at his papers, will be able to answer this with maybe some more depth. Although he might be so clever, he doesn't leave a paper trail either. You could look at it in one way of saying, go back to what Chief Justice Marshall, who was very much Chief Justice Roberts' role model, and he wants to be in that league along with the great Chief Justice John Marshall. In Marbury versus Madison, Chief Justice Marshall had this terrible dilemma of Secretary of State Madison had refused to deliver a document to Marbury. He'd been appointed Justice of the Peace by President Adams at the last minute of the Adams administration, and said, "You got to give me this paper." And the case went to the Supreme Court, and Marshall knew, boy, if I do this, this is just going to ignite a firestorm. And in fact, the Republicans, also called the Democrats at the time, the Democratic Republican Party, headed by President Jefferson, is getting ready to impeach one of my colleagues, Samuel Chase, for getting way out of line and being too political in his judicial duties. And who knows what they're going to do to the Supreme Court. Jefferson doesn't even like the courts that much. And if I rule against him, it could lead to a lot of trouble. On the other hand, this guy really is legally entitled to have Madison give him this document. And Marshall came up with a brilliant solution, which, I'm not saying he was being canny or strategic, but it sure worked out that way, which was, he says, Marbury, you're entitled to have Madison give you that document, but you know what? We, the Supreme Court, we can't order Madison to do that because the congressional law enacted about 15 years previously, which gave us the power to issue an order like that to the Secretary of State, that's unconstitutional. That congressional law expanded the Supreme Court's powers too far. And so reluctantly, we have to say that's unconstitutional.
He limited his own power so as not to upset the balance.
And in doing so, firmly established what had been around for a while, but this was the first case that exercised the power of judicial review, that the Supreme Court can say that a law passed by Congress is unconstitutional and therefore void. So with Marbury versus Madison, Marshall won a tremendous victory over the power of the federal courts and the vision of the Federalist Party, his party, for the government of the United States at the cost of inflicting a smaller defeat on himself in the process.
Let's bring it fast forward to 2012. And everyone today is thinking about the political ramifications of what this is going to be. I'm thinking down the road, this could be such a financial burden, added along with Social Security and Medicare, that it could be catastrophic for the federal government. But let's bring it all the way back to this fall, which everyone seems to be much more immediate. I got to believe this is a plus for Romney and Republicans. Would you agree? And tell me why.
Well, further down the road, it is a very big plus for constitutional government, for original meaning. We are a lot closer to that today on everything except the tax power than we were yesterday. On the spending power, on the necessary and proper clause, and on the commerce power, we now have very strong precedent that, as some of the most astute commentators like Lyle Denniston, the senior Supreme Court reporter in the United States, and even some of the more clever folks on Slate have been observing, there's a lot of stronger limits on Congress today than there were yesterday. And if it's at the price of the individual mandate, people thinking strategically in the long term might say that's a price worth paying. In terms of it certainly shows for the election, that the elections have consequences. And if you don't like Obamacare, then having a new president would be a good first step towards changing that.
But still, it's a long way to go to get a Congress and a Senate and a Republican president that are going to do that. This makes the Republicans have one issue. So it was the economy, now it's the economy and this, so I'll make it two issues. They've got two things to run on because this is still as unpopular as it was the day it was passed, maybe even more so.
There have been 98 public opinion polls on Obamacare. The record is 98-0. In every one, more Americans are against it than are for it. On the individual mandate, it's even more lopsided, and over time, public sentiment against it has grown and grown. So this is actually one of the cases where the Supreme Court went against public opinion and came to a result that the public didn't want.
Talk to me about this being a tax. During the debate, the president, the supporters of it said, this is not a tax, this is not a tax, this is not a tax, until it became law. And then in front of the Supreme Court, they say, oh, yeah, it's a tax.
Well, as President Nixon, his press secretary Ron Ziegler once remarked during Watergate, he said these previous statements are no longer operative.
Is that put on your take away your wonk hat, put on your political observer hat for a second. How does Obama handle this? Obviously this is a huge victory for him in one way, that it says, hey, I passed something, you said I was just a stupid law clerk that couldn't get things done. I got this done, and you said it was unconstitutional. Look, it's constitutional. Right. But at the same time, he's going to have to answer that question. You said it wasn't a tax. Now it is a tax. You said you wouldn't tax people under $250,000 a year. Now you are.
Well, and you said during the Democratic primaries that Hillary Clinton's health care plan had this big flaw that it ordered you to buy health care. And he said, that's like trying to solve homelessness by saying that everybody has to buy a home. So, yeah, if the contradictions between what he said in the past and the present are catastrophic for him, that would be a problem, although Mitt Romney has also had different positions on things over the years.
Then let's pull that one out. Mitt Romney yesterday made the statement, we got to repeal, we got to replace, I'm the guy to do it. But he did something very similar, not completely similar, in his own state. How does he pull this one off?
Well, you can make the argument, which is all the stronger today, that the 10th Amendment to the United States Constitution does stand for the principle that there's some kind of things that states can do as they act as social laboratories trying different things that the federal government doesn't. Or although he had written something in the early days of Obamacare saying maybe it'd be a good idea nationally. I think his point is, if you don't like the mandate, I'm against it. I'm against it after I was for it. And if you want to get rid of it, you got a lot better chance with me than the other guy.
We'll be percolating on this one for quite some time. Hey, check out the Independence Institute. That's independenceinstitute.org. Listen for me on KHOW Radio, 630 KHOW. Tell a friend. We'll see you next week.